Good morning. This is April 16th, House Government Operations and Military Affairs. And we are here to talk about S23, an act relating to the use of synthetic media in elections. Hearing more testimony this morning from the National Conference of State Legislatures. And I believe we're starting with Adam. And Adam, yeah.
Hello.
Great.
Yes, we are also joined here by Wendy Underhill.
Okay, so if you all would like to make yourselves comfortable and introduce yourselves for the record.
Yes, I'm Adam Kokuk. I'm with the National Conference of State Legislatures and our elections and redistricting team.
And I am Wendy Underhill, the director of the redistricting and elections team at NCSL. Glad to be here.
Morning. I don't think we've had you in before and maybe haven't met you since you're not based in Vermont. Is that correct? So maybe we can just go around the table really quickly. I'm Representative Lisa Hango and I represent Franklin 5, which is on the northwestern Canadian border with Vermont. And I'm the vice chair of this committee.
Representative Lucy Boyden, I represent Memorial 3, which is Cambridge and Moore.
Sandy Pincinel, I represent Bennington Rutland 1, which is Danby, Mount Tabor, Dorset, Peru, and Landgrove.
Michael Morgan, represent all of Grand Isle County, so the very northwest corner of Vermont and West Milton.
Hooper, the big city.
City guy.
Yeah, city.
B.L. Coffin. I represent Windsor District 2, so Cavendish, Weathersfield, and Baltimore.
Kate Nugent, a portion of South Burlington.
Hi, I'm Shane Waters Evans. I'm from Charlotte. I know Wendy. It's exciting to see you here. I'm the ranking member of this committee and Charlotte Heinsberg over near the lake, south of Burlington.
And we should be joined in a little bit by Representative Matt Byron from Hutchins, who is the chair of the committee. So thank you for being with us today, and I'll turn the floor over to you.
Right. Well, thank you so much, Vice Chair Hungo. It's a pleasure to be here with you all. This is Adam's second trip to Vermont for business purposes. It's my first trip to Vermont for business purposes, so I'm pretty excited to be here. We are going to talk about AI and how it relates to political messaging. I understand you've already heard the testimony on this, so you're probably more up to date, but we're going to tell you what we know and see how that goes. But first, I am required to do the a PSA for NCSL. So I want you to know we are the nation's bipartisan organization that supports legislators and legislative staff. So the staff are members of our organization as well. And we believe in the importance of the legislative institution. And we think that strong estates make a strong nation. So that's kind of our guiding principle. I do want to say that we've got a number of services that we provide, and the one that we're here to do today is about policy research. The bread and butter of our work is answering questions from legislators. So if you have a question that you would like answered on anything related to elections, we're happy to answer it. If you have a question that relates to any other topic, you can certainly pass it through Adam and me or through your state liaison, who is Erica McKellar. I don't know if any of you have had the chance to meet her. But we will farm it out to the right person and get you back the information that we can gather for you. If you give us more time, we'll give you more information. If you give us just 30 minutes, we'll give you what we can gather up in 30 minutes. And important to know that the work that we do is, in that regard, is confidential. So if you've got something you don't want your fellow committee members to know that you're asking about, we're not going to share it with anybody in your state or elsewhere. So that's helpful. I'm hoping that you have all heard that our legislative summit is taking place in Boston this year. You're going to get really sick of hearing that because we're going to send you emails over and over and over. It is August 4th to the 6th. It is NCSL's 50th anniversary, so that's kind of exciting for us. And there's a specific thing I do want to mention that is not yet showing up in the materials going out from NCSL as a whole. And that is that our team is going to do a one-day meeting on the Sunday, that's August 3rd, beforehand, just on election stuff. So we'll have 8 sort of current topics and just kind of do a quick hit on them with various experts. And what you need to know is that that's actually a free event. There is a big price to attend Summit, but there is not a price to attend this pre-con. We just need to know that you'd like to come. So I encourage you to come on down for that. And you could even encourage local election officials, perhaps in a more subtle and I don't need the room to be filled with all the Vermont clerks, but it is a possibility.
Thank you.
Now, on our agenda, you can see it up here on the slide. We're going to do a little bit of background, some scope on the laws, approaches to regulating deepfakes. There's one court case we thought would be important to look at, and then we've got some research and resources to offer. But what we're not talking about today here is how AI can be positively used in a campaign or in a election office. We're looking at places where it could be used for deception. So just to be clear, we're not trying to say AI it should never be seen anywhere ever, just this one particular piece of it. And Adam, I'm going to stop talking. We think we're going to have about 15 minutes. Maybe I've used the first 3, so 12 more minutes from us on this. And anyway.
All right. Well, thank you, Wendy, and thank you to the members of the committee for having us here today. So just to begin, I want to make sure we're all on the same page. So when we are referring to deepfakes today, we are talking about computer programs that create images, audio, or videos, usually through systems known as neural networks. Some of the common deepfake tools that you may have heard of before are Midjourney. OpenAI has a video program software called Sora, and then Adobe also has a program called Firefly. And then one more thing, when we are talking about deepfakes today, we are mainly referring to political deepfakes intended to influence an election. Now, just a quick history of deepfake election laws. Back in 2018, deepfakes were just starting to emerge. The technology was not anywhere near what it is today, and consumer end products were not very widely available. But as a result of this, only 2 states had enacted laws in 2018. Those 2 states were California and Texas. Fast forwarding a little bit, at the end of 2022, ChatGPT had released its newest version, and several generative AI tools had made some pretty big advancements at the time. And this brought AI directly into the public eye. So then over 2023, right after ChatGPT and all those advancements, we saw 3 states enact laws. Then in 2024, with the election quickly approaching, 15 more states enacted laws. And then finally this year, we have had 3 more states so far enact laws. And several bills are fairly far along in the legislative process in some states. So in total, we are aware of 23 states that have enacted a deepfake election law as of today. Now, what exactly are these laws regulating? So when looking at state legislation, you will often see a variety of terms being used to refer to AI-generated media. Often you'll see deepfake, but you'll also see terms like synthetic media, materially deceptive media. I've also seen doctored media used. These terms are all referring to the same thing, media generated by AI, but there are differences in how these terms are defined, which ultimately affects what's covered by these laws. So one of the biggest differences in how states define these terms are what types of media are included. So are they including images, video, and or audio? Now, these laws don't explicitly include text, like something that may be generated from ChatGPT, and they will often have exceptions for text. Now, most states include all 3 mediums, so that'd be images, audio, and video, but some states only cover 1 or 2. Texas, for example, only covers video deepfakes. So states will also mention certain methods of training these AI tools as a way to define them. Generative adversarial networks, often referred to as GANs, are one example. GANs are not the only way to train a deepfake generator. Diffusion is another example. Idaho and Washington are 2 states that use GANs in their definition. but there are also several others that do this as well. And often when these laws refer to a generative adversarial network, they will say also, they will also include in their definition or other digital technologies in that too, to catch anything else that is not a generative adversarial network. And then finally, some states don't mention any specific technology at all. So Minnesota, for example, defines a deepfake as a piece of media that is so realistic that a reasonable person would believe it depicts speech or conduct of an individual who did not, in fact, engage in such speech or conduct, and two, the production of which was substantially dependent upon technical means rather than the ability of another individual to physically or verbally impersonate such individual. Now, as we will get into in just a bit, these laws have generally gone untested in courts. So there's still questions about the applicability of these laws, but if written broadly enough, these laws could be applicable to content that was created without AI. So, say something was created through more traditional means like Photoshop, it might get captured by these laws as well. Now to how states are actually regulating deepfakes in elections. So there have been two main approaches, prohibitions and disclosures. Two states, Minnesota and Texas, prohibit the publication of an election-related deepfake a certain number of days prior to an election. In Texas, this is 30 days prior to the election, and in Minnesota, it's 90 days. The other 21 states with laws on this subject have some type of disclosure requirement, such as what this bill is seeking today. These disclosure requirements are similar to those that are required for campaign finance, where a committee must disclose for who paid an advertisement, as in it's printed at the bottom of the piece of media. It usually states something like this media has been generated or edited by AI. And the states that have a disclosure requirement also often have some sort of prohibition attached to it as well. Although the prohibition on the deepfakes does not apply so long as the disclosure statement is present on the deepfakes. So some more uncommon approaches that only a few states have employed are digitally embedded disclosures and social media moderation. Digitally embedded disclosures are requirements for certain information to be put into the metadata of a deepfake. So the metadata is essentially just the descriptive data about a file. So when it was created, who created it, what type of file it is, etc. So these disclosures require a deepfake's metadata to include what AI tool was used to create it, when it was created, and it also requires the disclosure statement that is printed on the deepfake itself to also be contained in the metadata as well. And Colorado and Utah are the two states that have this sort of digital embedded disclosure requirement. And California is the only state that requires large online platforms to create guidelines for identifying and taking down election deepfakes. This law also requires online platforms to take complaints from candidates and election officials who identify election deepfakes. And then one other thing to note is that California, Colorado, and Utah, they also have the more standard disclosure requirement in addition to these provisions. Now, as for how states enforce these laws, many states have chosen to leave enforcement to civil courts. Candidates in most states can seek injunctive relief to prohibit the further publication of an AI-generated image of themselves. Some states like Mississippi have extended a cause of action to other individuals that may have been falsely depicted, like lay people or public officials. And New Hampshire has extended a cause of action to election officials specifically. Now, several states also allow candidates to seek repayment of court costs and damages if they are subject to a lawsuit and prevail in court on the merits. So due to the increasing sophistication of AI content, people may bring lawsuits against real content claiming it is fake. And so Alabama has attempted to remedy this by allowing a defendant to obtain court costs and fees for frivolous lawsuits as well. And then states also may choose to impose civil fines. So New Mexico and Utah, for example, fine offenders $1,000 for each violation. Colorado has a somewhat unique civil penalty where they will impose a penalty of 10% of the dollar amount used to promote a deepfake. Then about a third of the states have also enacted laws that have criminal penalties specific to their AI political messaging laws. Although more uncommon than other penalties, some states have punishments of prison time. For example, Texas's law allows a maximum sentence of 1 year for a violation. Some prison sentences are tied to specific conditions, such as in Minnesota, where second violations have longer maximum sentences. In Mississippi, also, violations intended to incite violence can be given a maximum of 5 years, whereas all other violations carry out a maximum of just 1 year. And then some states also have criminal fines that can be imposed with or instead of prison time. Michigan's fine of $500 for the first violation is among the lowest, while Minnesota's fine of $10,000 for second violations is one of the largest that we've seen. Now, as I stated a little earlier, many of these cases have gone untested in courts. However, there is a case out of California, Coles v. Bonta. A content creator on YouTube was creating parody deepfakes of candidates during the 2024 election. They brought a claim that stated that these laws restricted their First Amendment right to free speech to create parody. The court in California agreed and granted a preliminary injunction on the law while this case continues to play out. And then I will also note that's not on this slide. There is one case out of Minnesota from the same plaintiff. However, that case has yet to be decided on the merits, and a request for preliminary injunction was denied on procedural grounds. And finally, before I pass it back to Wendy, I would like to just highlight a couple of databases. So as we've been discussing deepfakes, you may be curious to know how people have actually been using them. So several institutions listed here have databases that track and link to deepfakes that have been published on the internet. These databases take a global look at deepfakes, and thus they give more examples than just what has been found in the US. So with that, I will hand it back to Wendy.
Great, thanks, Adam. I know you know that every organization in the face of the planet has written a report on how AI might be used. There's only one report that we know of that actually has studied that, and that is called In Disclaimers We Trust, the Effectiveness of State-Required Disclaimers on Political Ads. This is written by Scott Brennan, and he's with the NYU Center on Tech Policy, and he published this report last year. He did talk to me on the phone a few days ago, and he made the point that, just like I said earlier, he wasn't looking at the many good ways that AI could be used. He was looking at deception and influence on elections specifically. So not trying to damn AI, just looking at these other things. So here's his takeaways. The use of deceptive synthetic media is not used much in campaigns yet in the United States. That doesn't mean it won't come. It is possible that candidates and campaigns are not looking to start an arms race on this, and there's just uncertainty. But as of right now, through the 2024 election, it's pretty minimal. Second, the impact on his study group of having a disclaimer is pretty minimal. When they looked at ads and were asked, do you trust this ad? Do you not trust this ad? The disclaimer was not a huge part of it, but the wording did matter. So if you said this has been edited or created with a generative AI, you're more likely to have people say, oh, okay. If you just said, this image is created, has been, I don't know what the right word is, doctored is not quite right, but if the disclaimer left room for Photoshop, then they were less likely to have a response. So by saying AI or generative AI or similar, the respondents had more of a surprise factor there. And the most intriguing of his outcomes is that when there are these disclaimers, it actually reduces the trust in the person who's putting that disclaimer on and the ad that they're putting out. And if you make an ad with a deep fake or synthetic media, and you put the disclaimer on, the audience trusts that ad and that candidate less than they otherwise would. So I do want to say that NCSL also has some resources, and we want to be sure that you got them. I think we've headed those off to Autumn, so those might be in your files, and those are both about AI in elections and campaigns and also otherwise. And now I just came up with a few things that I just wanted to sort of share my personal analysis here with you. And that's that deep fakes are new in the sense that they are being created with generative AI. Having false or misleading information is not new. So in a way, we see this in the context of decades of finding that line between what's misleading and what isn't, and whether it's okay to put up misleading ads in our nation. So the legal landscape, Adam gave you the one big case so far, but we can expect some more change on that. My thought is that it will probably follow in the same pattern as law around campaign finance, in that this is about disclosure, the right of people to know versus freedom of speech, and that's where the interest is going to be in the legal community as we go forward. And this is a nascent field, and I'm interested and don't yet know much about what the enforcement requirements are going to be for this. So the law goes into effect. Who is the enforcement agency? How are they regulating it? So it might follow, again, a campaign finance model. I don't know, but we will be tracking that in the next few years, because now we've got all of these states that have acted so fast. We'll be looking at how they put it into practice. It's one thing to pass the law, and then you have to implement it. And you did mention New Hampshire, and I really appreciate that. One thing I'm interested in is that a deep fake on a candidate is a bad thing. And also, if you did a deep fake on an election administrator, such as your Secretary of State, that's a bad thing too. New Hampshire has built this in that an election official has the capacity to seek compensation if that happens to them. And I think that was the end of what I had to say. And we're happy to take questions if you'd like now. And of course, in the future is fine too.
So I just want to reiterate that you have some concerns that by making a disclaimer, the candidate would be less trusted by the general public. Is that what I heard you say?
I thank you for that question. I am referencing the only report that I know that has used a sort of academic study where they brought people into a controlled environment and asked them to look at ads that did and didn't have them. And the result of that one study is that it might make the person who is using the generative AI look less trustworthy than if they didn't have that disclaimer on it. But that doesn't indicate whether they did use it or not then.
Okay. Thank you for that. So really, because it's such a new and emerging issue, there really isn't that much research. Is that what we can do that? Thank you. Representative Hooper.
Thank you. When you require the submission of the metadata representation, is that accessible by the platform that it's being placed on, so that if you or contest, they can immediately say that it's generated?
Yes, so the metadata of a file is generally accessible to anybody. So if you were to download the file, you would be able to look at the metadata on that file. So Yes, that is the purpose of it, is to be able to quickly identify it. And I mean, with it being a part of the file, when you upload it to a platform, presumably that platform can read the metadata and immediately recognize if it was generated as a deep fake.
Does that do anything to facilitate the resolution of complaint? Time-wise or?
I am not aware exactly, that process. But I'm happy to look into that and get back to you.
Cover cartoons?
Huh?
Discover cartoons?
Cartoons?
Yeah.
Oh,
Parodies,
parodies.
Well, not necessarily like an actual
like Bugs Bunny.
animated, yes, as opposed to a picture of.
Right. So if in the metadata, it would have, that information that identified it as a deep fake, then presumably, yes, it would identify images that are realistic or that are more artistic.
Any additional questions? Okay, thank you very much. We appreciate you coming all the way to Vermont and hope you enjoy your first taste of Vermont, even though we had a little bit of snow this morning in
It's pretty accurate.
mid-April.
Seems right.
And you're welcome to stay and listen to the rest of the testimony if you would like. And hopefully you're going to get a chance to look around our beautiful State House. This is a working museum. Our rooms are brand new this year, but the rest of the building has been restored to its original beauty.
Just even walking up the steps and seeing the Capitol and walking in the door, it's just breathtaking. It feels like this is where democracy lives.
It really is awe-inspiring.
I will.
You can get
Well, thank you again.
you can get the curator to give you a tour.
Yeah.
Love it.
And now we'll hear from Falco Schilling. And this is probably your first time testifying here, is it not?
That's correct.
Nice to meet you.
So for the record, my name is Falco Schilling, and I'm the Advocacy Director for the American Civil Liberties Union of Vermont, or the ACLU of Vermont. And as you've heard, this is my first time testifying in front of this committee, so I really appreciate this opportunity. Before I dive in, I should give a little context. This is a bill that we have not been following closely, but we did hear from folks on the committee that you would like to hear our opinion. So I did my best to reach out to folks who spend a lot more time thinking about these things and diving deep into election law and the intersections with the First Amendment, because often when the ACLU gets called to speak on these issues, it's where we have rights and freedoms intersecting and those areas where you have a really tricky interplay between those two. So before I start my testimony, I do want to say I really understand the intent behind the bill and what it's trying to get at, but also want to raise some concerns about the implications that it might have on people's First Amendment rights, especially as they relate to elections. So with that, I'll dive right in. And I'll also say, if there's any questions that come up during testimony that I might not have the answers to right now, I'd be happy to circle back with some of my colleagues and provide supplemental information to the committee, but hopefully this can be sufficient. So as I said, I'm Falco Schilling. I'm the Advocacy Director for the ACLU of Vermont. For more than 100 years, the ACLU and our 54 state affiliates have been among the nation's premier defenders of civil rights and civil liberties, including defending longstanding protections for freedom of expression through new and technological mediums. So I'm here to testify to raise some concerns around S-23 and its impact on speech concerning candidates in elections along the core of First Amendment's most crucial protections. So S-23 specifically does put burdens on speech about candidates and raises constitutional concerns. So to start off, S-23 would prohibit some core political speech that could potentially be in violation of the First Amendment as applied. Speech about political candidates, public officials, and public figures is often the core of First Amendment protections. The Supreme Court has emphasized that discussion of public issues and debate on the qualifications of candidates are integral to the operation of the system of government established in our Constitution. And so consequently, the First Amendment affords the broadest protection to such political expression in order to assure the unfettered exchange of the ideas for bringing about the political and social changes desired by the people. To that end, graphic depictions of politicians and candidates are often central to that political expression. As the Supreme Court has recognized, despite their sometimes caustic nature, graphic depictions and satirical cartoons have played a prominent role in the public and political debate. And consequently, graphic depictions, including those that depict candidates in a harsh or unflattering light, have been afforded robust protections. Those protections also extend to a great deal of knowingly false speech out of concern that the government will suppress core political speech, and courts have consequently resisted applying theories of fraud, deception, or libel to purportedly false speech. So in S23, the bill singles out core political speech with specific burdens and engages in a regulation of speech based on content, which triggers what is called strict scrutiny, which means that the law would receive the highest level of scrutiny by a court and would need to show that it's nearly tailored to achieve a compelling government interest to be found constitutional. And so one thing I want to talk about quickly is the disclosure requirement within the bill. And I know that the intent of the disclosure requirement is to try and ameliorate some of the concerns around the First Amendment. But our view is that that in itself creates some new First Amendment concerns. No other category of speech is required to make these disclosures. Consequently, the exception itself targets political speech, which are with certain burdens that are subject to strict scrutiny. In fact, the disclosure carries its own First Amendment implications. Government mandated disclosures on political speech are highly suspect under the First Amendment because they compel the speaker to engage in speech that they would otherwise like to avoid. And although the First Amendment allows government to compel factual disclosures in the context of commercial speech, such as in advertising and packaging, which is a place where there's often a lot of compelled speech, it does not ordinarily permit disclosure requirements outside of commercial contexts, such as in art, commentary, music publications, and a broad brush labeling requirement for non-commercial speech that is produced or manipulated by generative AI is subject to narrow public interest exceptions and is unlikely to survive a strict scrutiny test. Where the courts have upheld disclosure requirements, in election contexts, they have been limited to specific circumstances. First, they must be paid communications placed in mass media. And second, the disclosure relates only to the identity and source of the advertisement, not to the content itself. So S23 does not have those limitations as currently drafted. It extends beyond paid mass media communications, encompasses all AI-generated speech about candidates, including posts by private citizens on YouTube, a small blog, or shown only to friends. And second, the disclosure extends beyond the sources of the election-related spending. And such disclosures have been upheld because they ensure that the voters fully informed about the person who's doing speaking. Because of some of these concerns, the Federal Elections Commission has similarly decided to mandate disclosures for use, has declined to mandate disclosures for use of AI speech generally, as instead noted that existing law may apply where AI is used to mislead regarding the source of the communication. So one of the things that the courts have said is permissible is to make sure that folks know who is doing the speaking, but have engaged in a higher level of scrutiny when it relates to the content of the speech itself. And then there's some other concerns about the bill and some of the definitions in itself. Some of the terms are vague. The definition of synthetic media includes digital media that's been created or manipulated with digital technology, and nothing in the bill limits the application to generative AI. Instead, tools like Photoshop, Lightroom, and more could be caught up in what it's trying to define. And then also there's a concern that the exception for parody or satire is really hard to define and can be quite vague. As described, we've talked about before, satire and parody are key for robust political discourse, and they are terms that resist easy definition. Satire and parody are often based on exploitation of unfortunate physical traits or potentially embarrassing events, and exploitation often calculated to injure the feelings of the subject of the portrayal. What's clearly satire to one person is embarrassing and one-sided to another. Indeed, not everyone will agree what constitutes satire or parody, but the First Amendment does not depend on who's in on the joke. Likewise, although satire and parody are core to political speech, the First Amendment's protections extend beyond speech beyond those two categories, and attempt to shoehorn protected speech into those two categories could create some more concerns in application. And another concern is one of the enforcement mechanisms in the bill especially permits candidates to file suit for injunctive or equitable relief, essentially a court order to halt public discourse about a candidate running for election. This is something President Trump has indicated in a recent address to Congress that he would like to be engaging in. And it's a concern that we would see candidates using these tools to try and hinder the speech of other candidates in ways that could be impermissible. So in conclusion, S23 would attack some core political speech, chilling our national tradition of robust disclosure about candidates and politicians. And some better alternatives exist, such as more narrowly tailored provisions regarding intentional misrepresentation regarding the time, place, and legal consequences of voting, or more robust disclosures around the source of the content and who is paying for it. So I appreciate the time to share some of those views, and I'd be happy to take questions.
Questions from Mr. Schilling, Rep. Boyden, Rep. Cooper, Rep. Nugent.
Thank you for coming in and raising these. I wonder if you have any recommendations that sort of balance these concerns with anything that's already written in the bill or new things we could add. I think it's really important that in the same way that we are transparent with our voters with campaign finance and what is being paid for by who, we're additionally transparent with AI and things.
Yeah, I think one of the concerns here, and this is where it gets really tricky, is when you are trying to regulate the speech itself based on the content of the speech as opposed to who is doing the speaking or where that information is coming from. I think also the scope of the communications outside of mass media and other things are places where there's been some concerns raised. So it's one of those, I anticipate this being the first question when I get up on the stand is, all right, if you have all these concerns, what exactly can we do? And when I've talked to our folks, the places that they have pointed to where there is permissible regulation of speech in elections context relates to, who's paying for the mass media. And then also, as I said in the conclusion, restrictions around when it comes to content, any information regarding the misrepresentation of the place, manner, or legal consequences of voting. That's something that we think could survive a level of higher scrutiny.
Rep. Cooper?
So in the court's review of these type of cases, is one of the fall points intent? Goes along with the application of free speech. And is to broaden speech. At this point, seeing Bernie ad were depicted as being carried away by cops when he was 19 or something, as opposed to counterpart who was dressed in an American flag walking down the street. The intent clearly is to commute, but when your intent is to aim or misrepresent your ability to put the court's inclination to declare it free speech.
Well, I think as you heard earlier, there hasn't been a whole lot of cases on point with this type of regulation. In terms of the intent when it comes to political speech, I think that comes into play less, as we heard often in political speech. The intent could be to cast someone in a very negative light and potentially in a light that someone might not think is truthful or accurate or honest. Defamation does exist as an avenue for someone to get redress as an individual in these types of cases. But I think the intent behind it would be less persuasive to the court as opposed to the type of content that is being regulated within the regulation itself.
Rep. Nugent?
It's not sure my question's fully formed, but I'm just like I'm thinking about like the reason that the generation of the content matters in this case versus the impact. And I was thinking of like, I forget the topic, but there was some journalist that did some kind of very intense story that was very influential, but it turned out it was actually like a bunch of people's stories put together. And I think since that journalists are more careful about like saying these are, a bunch of stories in one. And I guess it's like, is it partly because it's so hard to tell the difference because from what's true and what's not, and it's like the impact that it's having that we want that, that we're thinking about, like we need to disclose this. Like, I guess, yeah, like the rights of the viewer versus the speaker. These are all the questions, but.
Yeah, in terms of, I think one thing that's hard is there's a lot of leeway given to speech in a political realm because of the really negative potential consequences of allowing regulation that chills that political speech and how we could see that weaponized against candidates in a way that could be extremely harmful. So I will say in my job, I often find myself in a position where it's difficult. People are raising real concerns around speech or content that has been shared, which is harmful and does cause actual harm to folks. But the concern there is often the slippery slope where we start the regulation of this speech. How can it be weaponized and used in ways to undermine our core rights? And often our concern is how it can be weaponized against folks who might have already been traditionally marginalized. And we've seen that occur as well. So I don't know if that answers your question, but it's an area where I will say some of the First Amendment testimony that I have to give in terms of encouraging folks to be very cautious around regulations in the area of speech can often feel really unsatisfying, but there's a reason behind the concerns that we're raising.
Oh, Rep. Waters Evans.
Right. So can you give me an example? I'm always a little skeptical of this slippery slope argument, but I understand it's also a thing. Do you have like a concrete example of when that was an issue?
In terms of regulation of speech in an electoral context where I don't think I can look for a more concrete example. I mean, I can think of a hypothetical.
Sure.
Where, you have candidates who, especially looking at the injunction provisions, are using that as a means to try and get injunctions to halt political candidates from being able to bring forward speech, whether or not it actually falls under the regulations you're putting forward, whether or not they are in fact constitutional. That's a way to chill that speech. That regulation being on the books can stop that person from speaking, get a court injunction, and then that can have a direct impact on an electoral contest that's happening at that point in time. In terms of satire and parody, those are things that are protected. And I understand that this bill aims to carve those out, but that's a difficult thing to do legislatively and could result in speech being chilled while there's a court case that is trying to decide whether or not something is in fact satire or parody. And sometimes that is in the eye of the beholder. And by putting more legal means to chill the speech of another candidate or a candidate you disagree with, that could have implications on their ability to fully communicate with the electorate.
Any additional questions? Great. Well, thank you very much for joining us.
Thank you.
Appreciate you making your first appearance in our committee. And now I think we're gonna switch gears.
All right. Yes. No, apologies for being late and missing the brunt of that conversation with Lieutenant Governor Rogers. Went longer than expected. All right, we're shifting over to 364, an act relating to the approval of the annexation of property by the village of Swanton. And we have with us Bill Sheets and Brian Savage. We have, Bill is the manager, Village of Swanton. And we have the town administrator, Town of Swanton. Gentlemen, how are you?
Very good. How are you? Thanks for having us.
Very
course.
good, thank you. Very good, thank you.
So, yeah, we took a peek at this last week and we just wanted to bring folks in for further insight on this. And I'm just pulling up the information that you brought into us, the maps again and a letter of support. So, I guess we can start with you, Mr. Sheets.
Yeah, thank you. For the record, I'm Bill Sheets, the Swanton Village Manager. We're essentially looking for your help. This is a contiguous property that the Village of Swanton purchased in 2023 for the purpose of kind of right-sizing what we're doing here. We've outgrown our current space. We're 42 full-time, 8 part-time, and 24 volunteer firefighters. And we are out of space across the board. Our current intent, if the next bond vote passes, is to move our electric department next door with the 20 full-time equivalents that go with them and all the equipment, meeting their 50-year needs while allowing our police department and public works to expand in our current space at 121st Street, really giving us a platform with this annexation of meeting the needs again of every department in the organization for the next 50 years.
Got a little bit of like brain freeze right now.
Can I just?
Yeah, please.
So I'm just looking at the map. So what it was gonna do is the yellow is what the village currently owns, and they're gonna take over all those the red, the outside edge of the red along that street.
That is correct. So the village currently does own the one in the red, 124, but it is currently in the town itself.
Okay.
Oh, okay.
That would be the annex part. Yes.
Yes.
And
And I believe we sent along a copy of the village charter. So Title 24, Chapter 279, 2E, which spells out the boundaries of the Village of Swanton may be altered at the discretion of the Board of Trustees with a concurrence of the General Assembly. We have had 2 motions authorizing me to pursue annexation under the old construct of the board, which was September 11th, 2023. And we had another unanimous motion to explore annexation by our Board of Trustees on April 14th of this year.
Thank you.
okay. No, I mean, we've, this is the second time we're discussing this. We're just trying to check all of our boxes to make sure that we're understanding it thoroughly, but at the moment, is anybody else seeing caution with this? Because quite frankly, I'm not.
Very straightforward,
Okay.
unless the member from Swanton feels different.
Brian, how are you? I just wanted to check in
Good.
with you and see if you had any input for us.
Well, good morning, Mr. Chair. Good to see everyone.
Yeah, good to
Some
see you again.
familiar-
How
Some
are
familiar
things?
faces. Good, they're doing well. For the record, my name is Brian Savage. I'm the town administrator for the town of Swanton. Last evening, and I sent a letter to this effect to the committee, the select board, this was discussed at the select board meeting, and they unanimously and fully endorse and support the annexation of 124 First Street into the Village of Swanton. The town and Village of Swanton are joined at the hip, literally. When Mr. Sheets had mentioned about the police department, the present facilities of the police department were inadequate. In my own opinion, from the day that the building that they're in was built, some 50 years ago. Since then, the village police has contracted now with the town of Swanton for 10 hours per day, 7 days a week protection. So they've greatly increased their territory and the population with which they serve. I do feel that at some point, this is my own personal opinion, but that relationship will continue and probably may even expand to parallel coverage. Truly, they are in an inadequate space. This will alleviate, the board feels that this will certainly alleviate that severe overcrowding in the existing complex next door. When the existing complex at 121st Street was built, that was also in the town outside of the village, and the village had to annex that one spot to make any meetings that were held there legal. So this is very similar requests. It's just fast forward 50 years and times have changed, of course. So we fully support it and look forward to a positive vote on May 6th so that the facility can get constructed, renovations done to the existing facility, and we go forward. Thank you.
Okay, understood.
Can I ask a couple of date questions?
Please.
Good morning. Nice to see you both.
Yeah, nice to see you.
I have a couple of questions on dates, just so I've got them correct for my notes. With regards to the village trustees affirmatively making a motion, that was September of 2023 and April of 2024. Did I get those years right, Mr. Sheets?
The second one is April 14th of 2025.
2025. Okay, thank you. And Mr. Savage, on May 6th, is the vote that you're holding a vote for a bond to construct a new facility?
Well, correction, the village is holding the vote for a bond
Okay.
vote for the new
Right.
facility for the electric department, not the town.
Right, because if successfully annexed, it will be village property.
That's correct. And it's for the village electric department. And I live in the village as well. I mean, I'm in the village. I'm a village resident. And so I kind of use the term very fluid. So yes, I will be voting personally on May 6th. But the board also supports that bond vote. It's the right way to go.
Thank you. Appreciate that.
Brett Hoover, sorry, I skipped over you there.
No problem. On your map, the hyphenated black line, is that the town village boundary that cuts through a lot of lots in the middle of them?
Yeah, Brian, do you have that in front? I don't want to misspeak.
I can take
believe
it.
that is correct.
I believe it is without looking at it. But that's that line, depending upon where Mr. Sheets got that map from, that line is not 100% accurate.
Oh, that's good.
It's if it came off the tax maps,
Yeah.
those are not guaranteed accurate.
Okay, thank you.
I've seen similar overlays in my community where they're just off by a smidge, but it represents the lots, like for all
Right.
intents and purposes. Yes, yes,
Yeah.
yes. All right. And so you have the bond vote coming up soon. So that is obviously something that is figuring this out, definitely. Thanks for that conversation. Is anybody?
So is this a committee?
No.
No.
No, it's a charter. It falls under the not subject to crossover municipal charter policy conversation designation. So Representative.
Just want to ask you if you feel that an affirmative vote by the legislature will be beneficial towards your prospective bond. We think alike very frequently. So would that be beneficial for your upcoming bond vote for voters to understand that the legislature has approved this or is in the process of approving the annexation?
I would categorize it as deeply appreciated and might avoid some confusion. I often wonder how far the reach and understanding is of the voting public on issues like this.
And I would agree with
Understood.
that.
Yeah, no. I mean, it just helps with the conversation with the voters, right? That like
Yes.
even if it's not through the entire process, at least like affirmative action by the House will signal that this process is in its process,
Absolutely, yes.
Yeah.
right?
And
Representative Morgan?
did I hear correctly, the current in yellow gentleman that was annexed by the village in an earlier time to become part of the village?
Yeah, that's where the existing village complex
Yeah,
is.
that was-
That was constructed in about 1979
Yeah.
and 1980, so around that time frame.
Then the red would become the next annexation.
Right.
Ooh, boy, be careful if I were you, Brian. I think there's a coup going on. All right, thank you.
Okay.
All right, gentlemen, I don't think we have anything further for you right now. I guess, my question for the committee is if we feel like we're comfortable with scheduling this for a vote. I mean, it's Wednesday. Let's take a look at this calendar. I mean, we could schedule this for a vote as early as tomorrow.
I do it tomorrow morning, I'll be
Yeah.
here.
What's that? Okay. All right, we will adjust our agenda and schedule this for a vote tomorrow. I will triple check with council to see if they have any flags, but I don't think they do. And we will get this thing out the door. That's out.
Right.
Okay, do we have
Thank you
anybody?
very much.
You got
Okay,
it, guys.
Thank you.
Yep, thank you. Yep.
And may I ask the table for a volunteer to shepherd this particular piece of legislation? Representative Hango. Ooh.
Well, it's Franklin County, what can I say?
It
I
is
know.
all yours.
Much appreciated.
It is all yours,
I'm
Vice Chair.
putting myself out there for you, Representative Walker.
You're welcome.
Yes, that's the part where you say thank you, Mr. Chair.
Right.
That saves me from saying, oh, another charter, cool.
That's good try.
So what we done?
Y'all got all excited.
All right, well, we'll get this on the agenda tomorrow for a vote, and we appreciate your time, guys. We are here as a
Okay.
resource for you if anything further pops up. Thank you so much for your time. We got about 15 minutes to our next scheduled order of business. So Autumn,